Hello and welcome to this talk about bringing a claim for judicial review. In this talk I'm going to be dealing with urgent cases. My name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers. The first question you need to ask if you're contemplating bringing a judicial review claim and you think it may be urgent is whether your application really is urgent. The reason for talking about this is that the administrative court has made it clear that in its view some litigants and indeed legal practitioners were misusing and even abusing the procedures that exist for seeking urgent adjudication of the case. So the forms that are used, to which I'll turn in a minute, have a requirement that you clearly state what the reasons are for the urgency of your case. And in this context, one of the features of judicial review, which I've dealt with in a previous talk, the duty of candour, is particularly emphasised. And for those of you who didn't see that talk, the duty of candour essentially means that you must disclose all relevant material to the court, whether or not it supports your case. And indeed, in a situation where you might be looking for an urgent application, the duty of candour is particularly important. So that means you definitely need to draw the attention of the court to matters which might harm your case. That's implicit in the duty of candour anyway. The Administrative Court Guide of 2016 also emphasises that you must comply with all the civil procedure rules, practice directions and other obligations when you're making an urgent application. If you don't, then as a defaulting party you're likely to be made subject to an adverse costs order. This is an order that you pay some or all of the other party's legal costs, or you might find yourself being unable to recover your own legal costs, even in the event of being successful overall. You run the risk, if you don't comply with these obligations, of having your claim dismissed for non-compliance. These talks are aimed primarily at litigants in person, but it's worth bearing in mind that a professional representative may face an application for wasted costs or may be referred to their professional regulator for consideration of disciplinary action. The warnings that are given to professional advisors in this context are particularly strong, and they include effectively naming and shaming of the legal representative, so that the case might be called on so that an explanation can be given for the failure to comply with practice directions, rules or other obligations, and where the representative has been at fault, the case name will include the name of the solicitor's firm or other legal representative. So there's an element there for the professional advisor of adverse publicity. If your claim is really urgent, you can use the urgent procedure where the circumstances of your case require urgent consideration of the application for permission to apply for judicial review and or any interim relief application that you want to make, such as for an injunction. Now, in certain situations you may want to make an application for relief in such urgent situations that you have to seek it before starting the claim. And I'll talk about those in the next talk. However, for the most part, even if the case is urgent, you can apply for urgent consideration at the same time as issuing the claim form. So the test for whether you should be seeking urgent consideration of the application for permission or the interim relief is to ask yourself whether the situation is one where some irreversible action will take place if the court doesn't act to prevent it. Or is it a situation where an expedited, that's a speedy, judicial review is required? And by that I mean where it's necessary and not just where it's desirable. The form you use to make an urgent application is form N463, and it has boxes that have to be completed, and these deal with the circumstances giving rise to the urgency in the first place. If you have to file the form only shortly before the end of the working day, you will need to give an explanation as to why the application wasn't made earlier in the day. Secondly, the form should contain the timescale sought for the consideration of the application. So, for example, does it need to be considered within the next 72 hours or shorter? What is the timescale? And you will need to relate that to the question of the irreparable damage that might occur if it isn't made in that timescale, and to justify the timescale that you've sought more generally. Next, you will need to specify the date by which any substantive hearing, that's the hearing of the merits of the judicial review claim, should take place. Next on the form, you should specify the efforts that you've taken to put the defendant on notice of your application for urgent consideration of permission or interim relief. Form N463 must also contain the grounds on which any interim order is sought, and you will need to supply a order in draft, so that's a written order setting out the relief that you're seeking and any directions that you're seeking for an expedited hearing. So those are the procedural orders in the case. So you would need to set out in that you're seeking a speedy hearing of permission or a speedy hearing on the merits, and setting out the relief that you're seeking in the intervening period, for example. Next, the full claim papers, that's the claim form and the supporting documents, which I deal with in an earlier talk. These need to be filed alongside the urgent application itself. One of the advantages of filing the full claim papers at the same time as your application for urgent consideration is that there's no need to pay an additional fee for the urgent application, as it's covered by the fee to start proceedings. You need to serve the claim papers and the form N463 and the supporting documentation on the defendant and any interested parties, and you must advise them of the application and the fact that they may make representations so that they are enabled to make those representations. There is a judge available to consider any urgent application which is received between 10 in the morning and either 4 or in London 4:30 in the afternoon, Monday to Fridays, excluding public holidays. The judge will consider whether to grant the urgent application, either by considering the papers on their own, or he or she may make an order that the application or a part of it should be dealt with at a hearing in court. The master, that's the procedural judge of the administrative court, or an administrative court office lawyer is also entitled to consider the application, and they may request further information from you, or they may make an order themselves. It's not appropriate for any urgent application arising in relation to a claim for judicial review to be put before the judge who deals with interim applications in another division of the court. There is a court called the Court 37, that's the court number in which these applications are heard, which deals with applications of an urgent nature, which are applications for things like injunctions. However, there is a specific judicial review judge who is available to consider urgent applications, so it's considered not appropriate to make the application to the judge who sits in Court 37 in the Royal Courts of Justice in London. Wherever possible, the court is going to want representations from the defendant before determining the application. And if you're seeking interim relief, the court generally makes an order allowing the defendant a short time in which to file written submissions before it decides the application. The exception to this is where irreversible prejudice would be caused to the claimant yourself in the intervening period. The other way in which the judge can deal with this point is to list the case, so put it in the lists for a hearing, so that the defendant has been given notice of the hearing and can attend to make representations. In cases where an expedited merits hearing, a substantive hearing, is sought, the court can shorten time for service of the defendant's acknowledgement of service. You'll hear that referred to as abridging time. The court can also request the defendant's views on the order which you're seeking, and this is done to enable the court to take an early view on permission and any consequential case management decisions. Where the judge hearing the matter or looking at the papers decides that the application wasn't urgent and was suitable for disposal according to the ordinary procedures of the court, the judge can refuse to deal with the matter on an urgent basis. The judge can also make an adverse costs order against the applicant or against the applicant's legal representative. I want to say something about the out-of-hours service which the court runs in respect of emergency applications. The first thing to say is that this is not available to litigants in person, and if you are representing yourself, you will need to obtain representation either from a barrister under the public access scheme or by a solicitor. Now, if the matter is very urgent indeed, you may need to do this by looking for the emergency number given by the barrister's chambers or by the solicitor's office. The out-of-hours service is used if the application cannot wait until sitting hours of the court recommence. In those circumstances, the claimant can make an application to the out-of-hours High Court judge. The out-of-hours High Court judge is a High Court judge who is on call at all times to deal with very urgent applications which cannot wait until the next working day. It is a matter for practitioners, and I'm going to assume that practitioners have the administrative court guide to bringing a claim for judicial review of 2016 in this slide. Here is the procedure you need to follow. First of all, you need to telephone the Royal Courts of Justice number, which is given at paragraph 16.3.2 in the guide. You will talk then to security. Security take the details from you and they will transmit those to the out-of-hours duty clerk. In the Administrative Court Guide at paragraph 16.3.3, you'll see the hyperlink to the form which you must download and fill out. You send it to the email address which is given in that paragraph, and it's important to note what the court guide says. Emails must not be sent to this address unless the out-of-hours duty clerk has invited you to do that. The process on an out-of-hours application is that the judge may deal with the application on the papers, or the judge may telephone the representative acting for the claimant to enable them to make their submissions orally before the judge decides the application. The representative is required to provide a telephone number on which they can be reached. The out-of-hours judge may also telephone any other party to the application if the judge considers that to do so would be appropriate. This is often done in immigration cases where there's an application to seek a stay on removal. The duties of the representative are as normal but slightly heightened in this situation. The judge is being asked to make an out-of-hours order, usually without a hearing and often without any representations from the defendant's representatives. The request is to be done in a short time frame. Now this means that the duty of candour, so this is the duty to disclose all material facts to the judge, even if they don't assist the claimant's case, is particularly important. Finally, the legal representative needs to consider whether the application is really necessary. They need to consider this very carefully in the case of an out-of-hours application. Is one really required? A legal representative should only make such an application if the matter really can't wait until the next working day. And paragraph 16.5.2 points out the type of conduct that will attract sanctions against the practitioner in this context.